everyone for your patience. The Senate Judiciary Committee is called to order. First on our agenda today, we're going to do a little bit of a switch in the initial order that we had because of scheduling. We are going to first hear Senate File 2216, and Senator Mann is here to present her bill for us today. Welcome to the Senate Labor Committee, Senator Mann.
Thank you, Madam Chair. Senate File 2216 would prohibit no-poach agreements between franchises and franchisees. So no-poach agreements are an agreement between employers that prevents franchisees from hiring away each other's employees, effectively limiting employees' job options. For example, for many years, such agreements precluded Jimmy John's franchisees from hiring each other's sandwich makers. So one employee could not go work at the Jimmy John's across town without explicit permission from their current employer. In 2016, it was estimated that approximately 60% of franchises had such agreements in place. What I find most troubling, and what we all should find most troubling, is that the employees whose mobility and job opportunity was restricted by these no-poach agreements never saw or signed them, but they could be turned away from a job because of them anyway. Madam Chair, we talk about free market, we talk about personal freedom, and these restrictive franchise agreements are the exact opposite of that. And this is evident by the fact that most franchises have now stopped doing these predatory practices, but not all of them. And with that, Madam Chair, I do have a testifier today who knows much more about this than I do.
Very good. If you wanted to invite your testifier up to the table. Oh, hello, on Zoom. Very good. Virtual. Oh, I see here in my notes.
Can you hear me okay?
Yes, pretty well. Just make sure to speak up, and we can see you and we can hear you. So welcome to the Senate Labor Committee. If you would introduce yourself, and if you could, for the record, also state where you're testifying from, and then we look forward to hearing your testimony.
No, thank you so much. Thank you to the chair and the members of the committee for the opportunity to testify today. My name is Evan Starr. I'm an associate professor at the University of Maryland at the Robert H. Smith School of Business, and I'm testifying today from the sunny state of Florida. So over the last decade, I've been studying the use and impact of restrictions on employee mobility. These include non-compete agreements, agreements not to solicit your clients, and no-poach agreements. I've published more than a dozen top articles on this topic, and I think this research broadly supports regulating no-poach agreements in ways that are addressed in this bill. And so what I wanted to do today is briefly summarize this research. The first thing to think about is, what are no-poach agreements? These are agreements between two organizations, or in this case, two franchisees of the same franchisor. These agreements generally operate above the heads of the workers, and they imply that two organizations will not recruit each other's workers. It's difficult to know exactly how common no-poach agreements are because they often are forged in secret, and due to their exclusive nature, they are generally illegal. An exception has been in that in the franchise sector, there's a current gray area, which this bill seeks to make less gray. But we know that from data from that sector, from franchise filings, showed that about 60% of franchises in the United States in 2016 used no-poach agreements, and that was up from 36% in 1996. So even though it seems natural to think that a low-wage worker, like somebody working at Jimmy John's or McDonald's, may not have trouble finding another job, the problem with these no-poach agreements is that they preclude workers from taking jobs for which they are in fact best suited. If a worker's lifestyle changes, for example, and they want to get a job at the franchise store closer to their new home or their kid's school or some other reason, then when they go to fill out the application, by putting down their super relevant prior work experience in the exact same franchise, when these agreements exist, they are unknowingly throwing themselves out of consideration. As a result, franchisees do not have to compete with each other for labor. So what impact does this have on wages? Well, there's a nice natural experiment that happened recently. The Washington State Attorney General started cracking down on no-poach agreements among franchises. And recent research by Brian Kalachi et al. Finds that wages among workers who were previously constrained by no-poach agreements rose 4% faster than other employers' wages. Affected workers here had a median annual earnings of about $26,000. So these are very low-wage workers. And the crackdown against employer collusion increased their wages by then approximately about $950 per year. There's a similar study of no-poach agreements arising from a very different context, which is the Silicon Valley no-poach case, where big tech companies agreed not to hire from each other. And the findings there are very similar. After the DOJ got involved, researchers found that a single no-poach agreement reduced wages, again, among these high-tech workers by about 2.5%. So what do these findings tell us about no-poach agreements and about the labor market? Well, they tell us that the labor market is, in fact, fragile. Preventing workers from moving to another employer or franchise where their skills are most useful has a meaningful detrimental effect on their earnings. And finally, I'll just conclude with this, that any arguments you can think of that might justify no-poach agreements, and there are some that are brought up, things like we need to protect investments in training our workers or in valuable information. I think we should be largely skeptical of those types of arguments because there is no need to go over the worker's head to protect those investments. You could have workers sign, for example, an agreement not to disclose information or an agreement to repay training expenses if they leave within a few weeks. And so just to summarize briefly, no-poach agreements have been super common in the franchise context. They have a detrimental effect on workers' earnings. And there are better ways to protect any employer interests aside from going above the workers' heads. I'm happy to answer any questions, and thank you so much for listening today.
Thank you for your testimony. Senator Mann, my intent then is to turn it over to our members for some discussion. Do you have any additional commentary? All right. Thank you, Senator, for the presentation of this bill. Members, discussion on Senate File 2216. Yes, Senator Dornick.
Thank you, Madam Chair. So I guess first I'd like to know the path of the bill. Do we know where it's going next?
Yes, Senator Dornick, next it is going to judiciary, I believe. That is my understanding. And then after, do you know after? Yeah. I think just to judiciary then, yeah.
Thank you, Madam Chair. I just have a couple quick questions. It's a pretty short bill. So I guess first question would be other states. Are we taking this from other states, or how many states now have this?
Senator Mann.
Madam Chair, I'm not certain. I think maybe Mr. Starr would know that.
Well, so what's happened in the last few years is once it came to light that most franchises had these sorts of arrangements, is the Washington State Attorney General started cracking down on these, and effectively got many of these franchises to remove them from their franchise agreements. And so, no-poach agreements have generally been illegal, and this law would help clarify that that's true in the franchise context as well. Obviously, the Washington Attorney General thought the same, and I think many others do. I'm not aware of exactly the number of other states that are considering precisely this legislation, but I know it's been an issue that's been discussed across the country over the last few years.
Senator Dornick, follow up.
Thank you. So is there data for the state of Minnesota on this? Any data that we have?
Senator Mann?
Mr. Starr?
Mr. Starr, if you have any information, we would take it. Thanks.
So there's a recent study by Peter Norlander, which I'll just point you to, where I believe he has data on franchise filings that come from the state of Minnesota. And his data indicate the use of no-poach agreements in these filings. And the one challenge is that I think that the filings may not be specific to franchises in Minnesota, even though he got them from Minnesota. So that's where there's a little bit of difficulty in saying this is the number in Minnesota. But the numbers were similar, I believe, to the Ashenfelter and Kruger, the 60% estimates cited earlier, which are from a paper by Orly Ashenfelter and Alan Kruger. But I'm happy to point you to that paper by Peter Norlander.
Thank you, Mr. Starr. If you could, I pass that information through Senator Mann's office. We can distribute that to the committee too. Thank you. Senator Dornick, follow up?
Yes, thank you, Madam Chair. I guess the other question, well, first I want to clarify. So do we have data of specific violators? Or are you just saying general of the complaints from employees, or is it just data from employers? I'm not exactly sure how that worked. This is the first time. I saw the bill just a little bit ago, so I think last night for the first time. So I'm not either for or against. I'm just trying to find out some information on it.
Mr. Starr?
So the data that, the first data that kicked all of the interest in franchise no poach agreements off was collected by Orley Ashenfelter and Alan Kruger, and they have a paper that, that it just was published in 2022, but it's been around for several years. And in the appendix of that paper, what they did is they drew on filings of these franchises. And so, you know, if you want to start a Wendy's franchise, for example, or a McDonald's franchise, you're going to go get documents which have to be filed, so anybody can access them. So all Ashenfelter and Kruger did was download all of these filings and just read through them and see which of these franchises had these sorts of agreements. And in the appendix, they published a table which listed all of the franchises which had these no poach agreements in their filings. And so that was the basis by which the Washington State Attorney General went after a bunch of these companies.
Thank you, Professor Starr. Senator Dornick, follow-up?
Last question is it more restaurants or is there other franchise box stores? Is it mostly with the restaurants that are the biggest violators?
Professor Starr?
Thank you. Yes, there are a number of, I mean, this is 60% of all of the major franchises in the U.S. So there are several that are fast food, but there are some that are not in the food industry. For example, I recall Jiffy Lube was one of these companies, and I think there's several more. So I'm happy to refer you to the appendix of their paper, which would list all of them. But they cover, my sense is they covered a broad swath of the economy, not just food.
Senator Dornick, any follow? Thank you. Senator Grunhagen.
Well, thank you, Madam Chair. Yeah, just a quick question. So are there any examples? I mean, how do they enforce this non-compete? To go to civil court or however they're doing it costs a lot of money. And I just don't, I mean, are there actually businesses that are trying to enforce this non-compete, or is it more like we're just sending a message to employees not to do this? Do you have any specific examples when an employer went after an employee where they made a change?
Senator Mann and Professor Starr, any thing to add to Senator Grunhagen's question?
We'll just add quickly, I'll let Professor Starr answer that. It's not a non-compete, so that's a little bit different. It's a no-poach agreement, and so it's not something that the employer enters into a contract with the employer. And so it's something that's done over their head, and so they have no recourse. They can't take anyone to court over it, as far as I understand. Professor Starr.
Yeah, that's right. The way these are typically enforced is via the HR professionals who are doing the hiring. And so, you know, there's no courts involved in this case. The individual hasn't signed any documents. In a typical non-compete case, a worker would have signed a non-compete agreement. And so in a non-compete case, if the worker was to violate that non-compete, they could be sued for breach of contract. The firm that hired them could be sued for tortious interference. And that's what enforcement would look like in that context. In the no-poach context, you just have an agreement between two organizations that says that they're not going to hire from each other. And the way that gets enforced is typically that the HR people who are doing the hiring, they see somebody's resume has that they worked on, at that same franchise in the few years before, and they just don't hire that individual. And if they do hire that individual, then there can be some emails going back and forth that say, don't do this again. But typically all this happens above the head of the worker. So there's no kind of legal enforcement that involves the courts, as in the case of a non-compete. And just to give you an example here, I have a list here from appendix of Ashenfelter's paper, just to give you a sense of the companies that have franchise no poach agreements in there. There's Amco Transmissions, Arby's, Bricks for Kids, Batteries Plus Bulbs, Building Stars, Burger King, Church's Chicken, Cinnabon, etc. There's a bunch of them.
Thank you. Senator Grunhagen, follow-up?
Oh, thank you, Madam Chair. Yes, so do you have a specific example where one business went after another one, where they actually initiated, some type of legal action, or is it just more or less they're sending a message to employees not to do this and then provide some hassling along the way? Or I guess I'm just looking for a few specific examples of where this was done in the state of Minnesota.
I think Senator Gruenhagen, and please weigh in, Professor Starr and Senator Mann, with more information, or to correct me if I'm incorrect, but my understanding of the way this works is this is an agreement between companies going over the heads of workers. So there's probably not many instances where you would see enforcement of this. We're trying to make sure that there is still competition in place so that workers can actually have options of different jobs that they could apply for, and that their wages won't be artificially kept low. And perhaps there's additional information you can add to that, but just the way that this works, I don't know if what you're asking for exists. But to that point, Senator Mann or Professor Starr, if you have any additional information, we'd appreciate it too.
I think something that might help would be just to read what one of these restrictions looks like here. So let me see if I can just pull one up here. Apologies as I'm scrolling on my screen as I'm just trying to find an example of some of the language here. But the thing to remember is that the way these are written, these are in the franchisor documents. So if you want to open up a new franchise of a McDonald's, it would be in your franchisor contract that you are then not allowed to hire from other McDonald's franchisees. That's how these are written. And so, when it comes to enforced, the types of things that that might be problematic then is if you were to hire from another McDonald's, what would happen in that case? And so it's different here than what we're talking about with a non-compete agreement.
Thank you, Professor.
And I'll come back here as I find some language here from one of these papers. So just give me a moment, and I'll come back with that.
Thank you, Professor Starr. While you're looking, Senator Gruenhagen, do you have any follow-up?
Yeah, just thanks for the response. I think I'm beginning to understand it better. It's agreement between businesses not to hire each other's employees and thereby keep them at a lower wage if at all possible. That's the way I understand it now. Okay. All right. Thanks for your responses.
Thank you, Senator Gruenhagen. Any further discussion? You go last. Okay. Senator Liskey.
Thank you, Madam Chair. Madam Chair, Senator Mann, I've been reading through the bill. I have, like Senator Dorning, just barely got time to get through this as we're in a very busy schedule as we've talked about. I see subdivision 4, the words severability. The first thing I worry about there is that there's a chance that something through this is unconstitutional. Can we direct us to what you might believe could be unconstitutional, and can we explain why that's the case?
Madam Chair.
Yes, yes, Senator Marty.
Madam Chair, I was going to comment on that provision as well, just because we don't need it, because our statutes have a provision that unless a provision in law says that something is severable, is not severable, it is severable. So it's meaningless language. I was going to suggest that to the author that she might remove it in the next committee. But somehow or another, some people drafting bills seem to think, some part of this could be unconstitutional, therefore we'll protect the rest of it. It's absolutely meaningless language in here, so I was going to suggest that you were raising it from the other side. So if there's controversy over it, I'd suggest taking it out because there's no meaning to it.
Okay, thank you, Senator Marty. And Senator Mann, to Senator Liskey's point or Senator Marty's point, do you have any additional information?
Yeah, I was actually going to say the exact same thing. When drafting bills, I was once told, always add that in, just in case, but there is nothing in this bill that I can point you to that I think will be unconstitutional.
Thank you, Senator Mann. Senator Liskey, follow-up?
Thank you, Madam Chair. Senator Mann, I think the only thing that I could see that you would want to include that type of thing in there for is that it's going to be retroactive to contracts that are already agreed upon. The concern there is that you are now entering contract law, and I believe Senator Marty is talking about some of the other side or the other viewpoints on that. But my concern is once a contract is signed, how enforceable are they? Do we hold them accountable to their contracts? That's something that I would be concerned about here.
Madam Chair.
Yes, Senator Mann.
Yeah, so that's why we added under the effective date, you will see that it's agreements entered into or amended on or after that date. So we did that very purposely so we don't wade into contract law.
Very good. Any follow-up? Okay. All right, Senator Dornick, the last word.
Thank you, Madam Chair. I just have a question on the language, line 2.6. You defined employee means an individual employed by an employer and includes independent contractors. So wondering what that exactly means. Who does that all encompass?
Senator Mann.
So if you have, and I am not a law expert, Madam Chair, but you can have independent contractors also be hired by franchisees or these companies, and we want to make sure that they are included in that as well, and that we don't have people regulating where they can or cannot work above their heads without their knowledge.
Thank you, Senator. Follow-up, Senator Dornick?
I'm just going to finish up, I guess. So the bill, I haven't got enough time to really look at it, so it looked like it makes sense. But again, there's unintended consequences that I'm not for sure yet. So I'm hesitant to vote for it because I don't know enough about all it's going to do. So it's always nice to have someone to speak to the other side. Which, have you spoken to any stakeholders that have any defense of what they're doing?
Senator Mann?
Madam Chair. Yeah, so the purpose of these agreements in the first place were, again, to restrict that movement of employees and to hold wages down, which is, of course, advantageous to the employer. This is not necessarily, it's not new language that's going to revolutionize the industry. These have been found to be illegal already. Most in some places, most franchisees have stopped this practice already. We're just, I guess, sending out a message that we want everyone to stop doing this.
Thank you, Senator Mann. Senator Dornick,
Just
follow-up.
one final. Yeah, so is there the data, I'd love to have it, and then some of the other states that do it and kind of the progress of throughout the country would be helpful to me.
Sure.
Thank you.
Thank you, Senator Dornick. And I'll just note also that the business community has legions of lobbyists, both at the state level and national level, whose explicit job it is to track legislation that is filed and to track how it is moving or not moving through our legislatures. So rest assured that members, if they have concerns about a bill, you'll hear about it. Senator Liskey, quickly.
Thank you, Madam Chair. Real quick, subdivision 3, back to that point that I was making, does enter into contract law. It talks about having to amend all franchise agreements, so that does enter contract law based on how that's written there. So that was my concern there.
Well, it sounds like perhaps you could take any concerns about that offline with Senator Mann as this bill moves forward, and if that's okay.
Yep.
Yeah, thank you, Senator Liskey. Senator Marty.
Madam Chair, I'll move the bill. I didn't know this existed, and it's disappointing here that the workers don't even know they're being denied this way.
No.
Anyway, I'll move the bill be recommended pass and referred to Committee on Judiciary.
Thank you, Senator Marty. On Senator Marty's motion, all in favor, please say aye. Aye. Any opposed? The motion passes. Thank you very much, Senator Mann. Thank you, Professor Starr, for your testimony. Next on our agenda today, we're going to go back to our first bill that we had on our agenda, Senate File 10, and Senator Seeberger is here to present her bill once again to the Senate Labor Committee. Welcome, Senator Seeberger.
Thank you, Madam Chair, members of the committee. I am proud to be back here on SF10 and to share that while not every issue has been resolved, stakeholders have had several productive conversations and have reached agreement on several items to ensure that this bill provides safe environments for workers and the general public, balanced with operational stability at refineries in our state. I will remind the members that our refiners are clearly understood to be high-hazard facilities that use chemicals that could be explosive or severely harmful to the environment or human health, both in and around the facility if not handled correctly. I would like to walk members through some key points on the amendments, which is why we're back here today, and I believe you should have 2 amendments in your materials.
Thank you, Senator Seeberger. We have amendment, the A14 amendment and the A16 amendment. Is that correct?
Madam Chair, those are the two amendments, correct?
Okay, very good. Senator, would you like to walk us through, starting with the A14?
Thank you, Madam Chair. All right, the A14 clarifies that the apprenticeship ratios mandated in the bill must apply to each contractor performing work at a refinery rather than to the refinery as a whole. And without this provision, we would have an exception that swallows the rule where workers performing one function could have no skilled and safe workforce requirements altogether. This amendment also finds common ground between labor and the refiners in reducing the apprenticeship ratios required in the bill while maintaining the phase-in structure to incrementally increase ratios over time. The A14 also includes two provisions providing flexibility to refineries to ensure operational stability and safety, both of which the labor stakeholders strongly agree are necessary and worthwhile exemptions. The first is a 48-hour right of refusal, where a refinery must seek apprenticed workers from a labor organization, but can bring in non-apprenticed workers for a period of time if the labor organization is not able to supply the requested workers within 48 hours. The second provision is an exemption if an emergency requires immediate action to prevent harm to public health, safety, or the environment. Again, both exemptions are strongly supported by labor and the refiners and will work to ensure operational stability and compliance that is not overly burdensome while still prioritizing workplace safety. And a final key change on the A14 amendment is a project labor agreement off-ramp, which is supported in concept by both labor and refiners. A PLA is an agreement to have a collective bargaining agreements with labor unions for all roles filled by trade workers at a refinery. The PLA off-ramp would exempt refiners from other requirements of this bill if they had a PLA for every aspect of work performed by the trades. This gives management flexibility in determining how to be in compliance with the requirements of SF10. That is the A14 amendment, and I will note it has come between the time I was first before this committee and today. Negotiations have occurred, and this is the result of that. So I'm pleased to say that the parties have been able to continue to negotiate and work to make this bill better.
Thank you, Senator Seeberger. Members, would someone please move the A14 amendment? Thank you. Thank you, Senator Hauschild. On the A14 amendment, all in favor of adopting the A14, please say aye. Aye. Any opposed? The A14 amendment is adopted. And members, we will continue to discuss the bill after it is amended as well. And to the A16, Senator?
Thank you, Madam Chair. The A16 simply amends effective dates to better reflect the business model. So you'll just see that it's nothing but adjusting the dates so that it makes more sense with regard to the actual business it addresses.
Very good. Thank you, Senator. Would someone please move the A16? Thank you, Senator Hauschild. Senator Hauschild moves the A16. All in favor of adopting the A16, please say aye. Aye. Any opposed? The A16 amendment is also adopted. All right, Senator, I'll just continue to hand it over to you, and I believe we have a testifier also to talk about the bill in its current form.
Thank you, Madam Chair. Members of the committee, I have Chris Taylor Forrest with me to help answer any questions that might be on the minds of members of the committee. I don't have a whole lot to add other than, you heard the importance of refinery safety and the need to have workers trained to a threshold so that when they're working side by side at the site, they have confidence that the person next to them knows what they're doing, has the ability and the skills to work in a dangerous facility like an oil refinery. So like I said, I am pleased that the parties and the stakeholders have continued to negotiate. This is the product of those negotiations, and I'm quite pleased with how the bill stands at this point.
Thank you, Senator. And we do have a testifier, John Beshy. Good afternoon, Mr. Beshy. Welcome to the Senate Labor Committee. If you'd just introduce yourself for the record, and we look forward to your testimony.
Thank you, Madam Chair, members of the committee. For the record, John Beshy with Associated Builders and Contractors of Minnesota, and I do appreciate the opportunity to be able to offer some additional closing thoughts on Senate File 10. While we appreciate the decrease in the apprenticeship ratios made by the A14 amendment, ABC does remain opposed to Senate File 10 and the mandate of registered apprenticeship programs on private construction. This has never been done before in Minnesota. There continues to be a misconception that the absence of a registered apprenticeship program has a negative impact on a contractor's ability to perform work safely, and this just couldn't be further from the truth. Our members have partnerships with MNOSHA, industry-leading safety programs, and they also have customized in-house safety programs, craft training, and much more, even though they aren't registered with the state. They take pride in their work and even more in the safety record for their employees. There are several reasons that a merit shop contractor may not choose to participate in a registered apprenticeship program. For example, merit shops often choose to provide that in-house training due to a specialized nature of their trades and markets. The breadth of requirements in registered apprenticeship programs are not tailored to these specific crafts. ABC members also employ multi-skilled craft professionals who are capable of performing different types of work rather than limiting themselves to one trade. Current DLI requirements, however, limit these professionals to a particular skilled trade for the purposes of a registered apprenticeship program, making it difficult to accommodate these multi-skilled craft professionals. It's not uncommon for our members, carpenters, for example, to help pour concrete or tie rebar. This sort of efficiency may make some uncomfortable, but it's what makes our members so successful. It's been said that anyone can start a registered apprenticeship program, and in theory, this is true. However, in practice, merit shop contractors have seen pushback from the trade unions when they've attempted to start a new registered apprenticeship program that competes with a union program. For example, ABC experienced intense opposition when first pursuing our registered apprenticeship program in the early 2000s. Anyone can submit comments on these proposals, and the trade unions submitted comments to the Department of Labor to pressure them not to approve our program. While our program was ultimately approved, it was extremely disheartening that such efforts were taken to prevent the approval of merit shop program solely for the reason that some folks are uncomfortable with fair and open competition. So if the requirements in this bill move forward, we sincerely hope that we don't see additional efforts on behalf of the advocates of this bill to oppose merit shop apprenticeship programs if we have members who try and start them. While we are strongly opposed to the concept of mandating one-size-fits-all apprenticeship programs on private business, ABC members are resilient and will adapt to this mandate if they are forced to. Our merit shop contractors and their multi-skilled craft professionals will remain competitive and will continue to gain market share in Minnesota's construction industry, just as they have been doing for years. In closing, I strongly encourage the committee to vote no on Senate File 10 and to allow our contractor members to continue to utilize the training programs that work best for their business and produce high-quality multi-craft professionals. Thank you again, Madam Chair and members of the committee, for the opportunity to provide our additional thoughts on this bill.
Thank you for your testimony. We do not have any other additional testifiers who signed up to offer testimony today, so before we begin our discussion with the committee, I will just turn it back to you, Senator Seeberger, if you have any final thoughts.
Thank you, Madam Chair, members of the committee. I don't have a whole lot to add. I'm so proud of this bill and so proud of the way the stakeholders have come together. Thanks.
Thank you, Senator. Members, discussion. Sure, Senator Dornick.
Thank you, Madam Chair. First to start, I really appreciate the hard work that's gone into this bill. Working with stakeholders, I know when we first came through, it was a room full early in the session and a lot of emotions, and got to learn a lot about both sides. So thank you for your work. Appreciate working with, again, the work that's been done on this, and this is the process that it's supposed to be done, getting and working together. Now, safety is number one for all of us, so that's not to be disputed. As I talk about some of the concerns I still have with the bill, it has nothing to do with safety, because the safety record that the St. Paul refinery has been recognized as an independent organization, including by the Minnesota Safety Council, Governor's Safety Award for the Awards of Honor of Occupational Safety for 2021, and performance for 2020, and 2022 was awarded the American Fuel and Petroleum or Petrochemical Manufacturers Distinguishing Safety Award, the highest safety honor, and one of the 4 refineries in the country with distinction. So they definitely are doing a good job. So I want to be careful with that. The biggest concern I have is when we were here and the guys that were going to lose their jobs, that was my biggest concern. And so as I've read this bill and the changes, I appreciate many of the changes, but there still seems to be that there will be some contractors or workers that will be let go because they won't be able to fit this 30, 45, 60. So I would just ask, is that true or not?
Senator Seeberger?
Thank you, Madam Chair. I would ask Mr. De La Forest to address that concern.
Thank you, Mr. De La Forest.
Madam Chair, it's Senator Dornick. Good afternoon. Now, for the record, Christopher De La Forest, representing today the Minnesota Building and Construction Trades Council, representing approximately 80,000 unionized construction professionals across the state. Senator, to answer your question, it's hard to say because, as you well know, given your background, construction is transient by nature, almost in the same way a dentist doesn't work on the same tooth every day. So to say people let go, as you know, people who work in this industry move from job to job. They come in, they come out, they work at different employers each day. So I think at the outset, it's hard to say that somebody would be let go. Now, it is true that there are standards for people to come and work in the oil refinery in this inherently dangerous facility, and we see that as a feature of the bill, not a bug. We definitely want to create a standard that people have to meet if they want to work here. But I point out, for example, there are numerous safe harbors starting explicitly that even at full phase-in, if you look at Amendment A14 1.25, it's a 60% requirement at phase-in. And so if you have that particular worker who self-taught welder, I guess, who does a great job, if their contractor, if their employer finds them to be that valuable to the organization, they could certainly fall under that 40% that isn't required to fall under the standards. So I would hope a contractor wouldn't have more than 40% of their workforce that would be ineligible under the minimal standards of the bill.
Thank you. Senator Dornick, follow-up.
Yeah, so my understanding is that they have many contractors, as in, I don't know the number, but quite a few. So that makes it's not like 4 or 5, it's a higher number that specialize in just certain areas of the refinery. And so that is my concern as I've talked to stakeholders that are, so how do we address that? And I think I appreciate the 30, dropping it down to 30, 45, and 60, but then it's, where you change the contractor is kind of the issue I think that's still left that I've discussed with the 2 refineries. There's still that sticking point. So would really like to have that worked out before I could support the bill, or have that assurance that there's not going to be workers that have been there for years not being able to have a spot. And I don't understand all the nuances of a petroleum, that facility and how their workers work, but it's a very, as you said, we want guys, and the workers there well-trained, and the ones that have been there for many, many years are well-trained. So that's my biggest concern, is to making sure that those workers that have been there for years can stay there. And as I've talked to, like I said, the stakeholders, they're concerned with that it would be a problem, and there will be people losing their jobs. And so that's the part that I have a hard time with.
Yeah, if I might, Madam Chair.
Yes, go ahead.
Thank you, Madam Chair, and Senator Dornick, I appreciate the question, and I think we've tried to to clarify at the outset, I know that it can be confusing, and I don't mean that you're confused about this, but this bill applies only to the employees of those contractors, outside contractors who come into work at the refinery. So just to clarify, there are direct employees who work for these refiners every day. They are employees of the refinery. They are not covered by this bill, just as a point of clarification. And Senator Dornick, appreciate your question. You know, we have tried to address this issue, and as a matter of fact, in the A14 amendment, starting on line 1.2, we try to talk about those very common occupations that you find a registered apprenticeship for, such as being an electrician, being a pipe fitter, et cetera, and have tried to define it that way, meaning that if there are some very, very specialized one-off type of occupations that are out there at the refinery, it has been our intent to exclude them. We're trying to talk about those occupations for which there is a registered apprenticeship program, and the folks who are subject to the bill, we all know about that. We know who those folks are. You can call the Registered Apprenticeship Training Center for the particular craft, and they will have an apprenticeship program for that. So to be clear, we have not tried to encapsulate more occupations that really don't fall within the bailiwick of those type of outside contractor jobs. I know, for example, one thing that we've talked about is, I know that security is sometimes hired. They're contracted for out at the refinery. That's an example of we're not looking to cover. There may or may not be a registered apprenticeship program for that. I don't know. Again, we're talking about those things that we know about construction trade professionals, like the electrician or the carpenter or the millwright.
Thank you. Follow-up, Senator Dornick?
Yeah, so thank you for that. So there's not quite peace in the valley. Is that correct? There's still some issues. I know you've been in negotiation, and I appreciate all that you've done and keeping me informed. So I thank you for that. But there's still some issues, correct?
Mr. De La Forest.
Thank you, Madam Chair and Senator Dornick. Right. There is not universal agreement. I think a lot of my perspective, of course, I would not presume to speak for counterparties, but my perspective is that a lot of progress has been made and a lot of the issues have been addressed. Have all of them been addressed? No. Will we reach 100% peace? I don't know. That would be the goal, I would think, of all the parties. We continue to talk. We continue to work with each other. I know we've got some discussions planned even for today after this hearing. So, well, of course, I wish I could promise a particular result for you and the committee. I know from my side, we pledge we will continue to work in good faith to try to resolve all outstanding issues.
Senator Dornick.
Thank you for that. I appreciate that, and that's what I wanted to hear. I do have one amendment. I brought it up. I'm not sure if Senator Seeberger had a chance to get, but it's the A15 amendment.
Okay.
I think it's a friendly amendment.
Okay, thank you. Senator Dornick is offering the A15 amendment. While we pass it out and make sure everybody has it, to your amendment, Senator.
So it's on page 3, line 12, and we're just clarifying that those original equipment manufacturers are installing the equipment that may be under warranty or to be able to have the manufacturing, that warranty. So that's really all it does, is adding to install the original equipment manufacturer.
Senator Seeberger.
Madam Chair, Senator Dornick, first of all, I want to thank Senator Dornick for approaching me prior to this hearing to talk about the amendment. I always appreciate it when I've got a little time to consider changes or proposed changes to a bill, so thank you for doing that. I've had a little bit of time to think about it and talk about it. I can't think of a reason not to agree to it, so I will accept it as a friendly amendment at this time.
Thank you, Senator Seeberger. On Senator Dornick's motion?
Yes.
On Senator Dornick's motion to adopt the A15 amendment, which Senator Seeberger has informed us she views as a friendly amendment. All in favor of adopting the A15, please say aye. Aye. Any opposed? The A15 amendment is adopted. Anything further, Senator Dornick? Okay. Senator Gruenhagen.
Oh, thank you, Madam Chair. Yeah, thanks for the, I would ditto the comments about thanks for the changes and working on this, and it definitely has moved in the what I would consider to be the right direction, okay? So I still have concerns also, but specifically I want to talk about the A14 that's now part of the bill. And on line 1.3, it says, within 48 hours of the contractor's request, excluding Saturdays, Sundays, and holidays, and it talks about, having worksite and labor organizations for a particular update or whatever. And then it goes on to, on the back of the bill, it has an exclusion for emergencies. And that if it's an emergency, evidently the employer can do whatever they have to address the emergency. Well, to me, I just think we're opening a little bit of a can of worms here, okay? I mean, first, what one person says is an emergency, the other person might say is not. Secondly, what might not be an emergency today can easily turn into an emergency, and you're talking about a refinery. We've seen refinery fires, in different parts of the country, I think of Wisconsin also, and these tend to quickly get out of control, and to me, you're tying the hands a little bit of the refinery in terms of addressing a particular update or whatever. Again, what one person considers an emergency, the next person couldn't, and yet this language seems to insert itself into the local judgment of management at the site. So why don't you give me a little pushback or what your thoughts are? Again, it's specifically line 1.3, within 48 hours of the contractor's request, down to 1.31, excluding Saturdays, Sundays, and holidays. So you're talking about 48 hours during the work week, and if it was Thursday, Friday, you can't count Saturday, Sunday, and holidays. Well, these refineries, my understanding is they operate around the clock, and it's of great concern of mine to see us insert ourselves as a legislature with statute into those types of decisions that they need to make at a local level, if they'd like to respond to my concerns. Madam Chair.
Thank you, Senator Grunhagen. I guess my concern on those provisions would be perhaps in the opposite direction, but I will let you speak to that, Senator Seeberger or Mr. De La Forest. Thank you.
Thank you, Madam Chair. And Senator Grunhagen, thanks for the question. I think at the outset, these, to be clear, are two separate exceptions. The first exception only has to deal with staffing the job, if you will, what I think we call in the industry the right of first refusal. So to give you an example of that, under this law, or perhaps under a PLA, the refiner calls up and says, hey, we need 100 steam fitters for this job. And within 48 hours, the contractor needs to produce those 100 steam fitters. And if they don't, then the refiners, the owner-operators, are relieved from their obligation then to follow the statute or the PLA, and they can go hire their own folks. The second part of what you referenced, and by the way, I got confused because you're referring to I was looking at 1.3, not 1.30.
Oh, I'm sorry.
In any case, and the second exception you were talking about is a whole separate one regarding emergencies. And I would say that is left within the discretion of the refiners. They decide what an emergency is. Of course, one of the flaws we have in crafting legislation, as you know, is we can't account for every situation and how we define an emergency. But what I can tell you, at least from the trade's perspective, is we are comfortable leaving that within the discretion of the refiners, especially with Flint Hills. We have long-standing relationships. The folks who work out there, I know we're clashing down here at the Capitol a little bit. They know each other, and I think they more than likely would agree on what would be in an emergency. And if somehow there were a dispute that the emergency was over or never was one, there are certainly procedures in place to adjudicate those things. But I would note finally that it was the refiners that asked for this particular exception, and certainly we thought it made a lot of sense. By way of information as well, the other states that have a Safe and Skilled Workforce Act also have this emergency exception looking much like the language you have before you in the A14.
But those provisions, just for clarification, those are compromise provisions, is that correct?
Madam Chair, they were the subject of discussions that we've been having, and certainly the trades have no objection to them. They make sense. As a matter of fact, can frequently be found in other agreements like site-specific agreements that we have. So yes, I think the subject of agreement would be fair to say.
Thank you. Follow-up, Senator Grunhagen?
Oh, thank you, Madam Chair. Yeah, thanks for that response. It's just, we're dealing with a refinery and explosions, and things get out of control very quickly. And, I'm a lay person, but I just think, what is routine today in 48 hours can turn into an emergency if it's not addressed with proper staffing. And to not have management to be able to respond in a quicker time frame, I think is detrimental to the operation of the refinery and also to the safety of the refinery. Again, what's routine today for staffing or what needs to be done can turn into an emergency well within the 48 hours. So, Madam Chair, I would actually propose an oral amendment that would strike on line 1.30 after the comma within 48 hours of the contractor's request, excluding Sunday, Saturdays, Sundays, and holidays. I would strike an oral amendment to strike that phrase out of the A14, which is a part of the original bill right now.
Thank you, Senator Grunhagen. I'm just going to consult with our committee counsel here.
Madam Chair and members and Senator Grunhagen, so the way I understand it is you want to delete on 1.30, delete within 48 hours of the contractor's request excluding Saturdays, Sundays, and holidays?
Correct.
So this, I'm not, so it's an exemption right now from having to follow the percentages after the 48 hours. So we can certainly make that, you can make that motion, but I'm not certain how it would exactly work with the exemption language. But on line 1.30, after paragraph D, delete within 48 hours of the contractor's request excluding Saturdays and Sundays and holidays. And I believe that's what you want to exclude.
Correct.
To delete.
Madam Chair?
Yes, Senator.
Yeah, and, according to testimony, it just applies to staffing, and they have to wait 48 hours. If they can't provide the proper staff, then they can go outside those limits. I just don't think you need to wait 48 hours. If the staff's not available to address whatever the concern is, we need to allow them to put the people and the staffing on site as soon as possible. Again, what can be routine today in 48 hours can turn into an emergency. And I just think we're inserting ourselves into a decision-making process that is best left at the local level. So I'd encourage members to vote yes for my oral amendment.
Thank you, Senator Grunhagen. And just so that we're all very clear, could you please, Council, repeat the oral amendment so we're all on the same page?
Yes, Mr. Chair, members, and Senator Grunhagen. So what Senator Grunhagen is saying is that if you get rid of that 48-hour language, that it would just make it immediately if they're unable to receive sufficient workers for the contractor to comply with this. So on line 1.30, after paragraph D, delete within 48 hours of the, and then on line 1.31, delete contractor's request excluding Saturdays, Sundays, and holidays.
Thank you. Thank you very much. Senator Seeberger, to the oral amendment.
Thank you, Madam Chair. Senator Grunhagen, the I'm hearing what you're saying. If I understand your concern, you don't want the refinery to be hamstrung by a period of time and unable to fill spots that they need, with the concern being that it could be an emergency situation that requires
turn
immediate
into
action. And I want to reassure you that that situation is already covered in this bill through subsection F, which relieves a refinery from having to comply with these provisions in the case of an emergency situation, whether that occurs immediately, shorter than 48 hours, after 48 hours. So that already exists in this proposed language. They already have that relief. They already have a mechanism to address a situation where time is short and workers must be acquired now. So because that situation is already addressed, more importantly, because the stakeholders have agreed to this 48-hour position, I would urge members to vote no on the oral amendment.
Madam Chair?
Thank you, Senator. Yes, Senator Grunhagen.
Oh, thank you, Madam Chair. Yeah, thanks for your response, Senator Seeberger. Yeah, the thing is, what is not an emergency today in a refinery area can quickly turn into an emergency if it isn't addressed with proper staffing. That's my concern. So I just really think removing this just is a speed bump to management initial response. Well, we don't have the initial staffing, so I got to wait 48 hours to get the other people in here to address this. Well, who knows if that turns into an emergency during that 48 hours. And then you can't count Saturday, Sunday, or holidays. So we're talking, 48, 96, it could be 4 or 5 days. And who knows what could happen within that period of time. And again, a refinery is an explosive area. We've seen that across the United States. And the amount of environmental damage that happens when something like that happens is fairly significant. So I just think take this speed bump out of local management, and I don't think we should be inserting a statute into a 48-hour wait in a management decision. And part of it, Madam Chair, and I'll make this brief, when I was chief negotiator in the school board, they had, before I got on there, they had negotiated that the superintendent had to keep track of who he asked to do certain things like man the lunchroom. He had to keep track of who he asked, in the order he asked, and how many times he asked, and who served. I mean, that just, it just got ridiculous. And the thing is, we finally got that removed in negotiations, but I see this going down the same type of a path, okay? Only in this case, it's not just a school, it's a refinery that can have serious detrimental effects.
Thank you, Senator Grunhagen. I think, I don't mean to cut you off, but I definitely want to move forward.
Roll call, please.
You would like a roll call on your oral amendment? Okay. Any final comment? I think we have your opinion on on Senator Grunhagen's oral amendment. Very briefly, Senator Dornick.
I would, thank you, Madam Chair. I'd like to hear Mr. De La Forest's comment on this, if he can, if he would.
Mr. De La Forest?
Yeah.
Any response? Mr. De La Forest, if you have a response to the oral argument, you may give it, but you are not compelled to do so by the committee.
I understand the chair's intent. I think, Madam Chair and Senator Dornick, in my view, the oral amendment for a number of reasons would be wholly impractical and would not work either for unions, their contractors, or the refiners.
Thank you.
Thank you. On Senator Grunhagen's oral amendment, please take the roll.
Oral amendment, Chair McEwen.
No.
Hoschild. Dornick.
No.
Grunhagen.
Yes.
Kupek.
No.
Liskey. No. Marty. No. Umu Verbatim. Pappas.
No.
Wiesenberg. No. Hoschild.
No.
8 noes, 1 yes.
Thank you. The oral amendment is not adopted. Members, further discussion? Okay. Thank you very much, members, for some good discussion on this bill and its evolution coming back to us. Members would, well, before we do that, Senator Seeberger, any last comments?
Thank you, Madam Chair, members of the committee. Thank you for allowing me to return with the good work that's been done with the stakeholders, and I would ask that the committee vote yes on my bill. Thank you.
Thank you, Senator Seeberger. And typically, I would give Senator Seeberger the last word. Senator Dornick, do you have final comments?
I'm not going to say anything other than the path of the bill. That's all. I want to know where's it go next.
We have the path of this bill being next to the Finance Committee. Yes. Okay. Members, would someone like to move that Senate File 10 as amended be recommended to pass and be re-referred to the Finance Committee? Thank you, Senator Marty makes that motion. All in favor, please say aye. Oh, I'm sorry. No? Oh, thank you. Thank you, Senator Marty. A roll call has been requested. It will be granted. On Senator Marty's motion to move that Senate File 10 as amended be recommended to pass and re-referred to the Finance Committee, if you would please take the roll.
Senate File 10, Chair McEwen.
Yes.
Housechild.
Yes.
Dornick. Gruenhagen.
No.
Kupek.
Yes.
Liskey.
No.
Marty.
Yes.
Verbaeten. Pappas.
Yes.
Weisenberg.
No.
5 yes, 4 no.
There being 5 yeses and 4 noes, the motion passes, and Senate File 10 is on to the Finance Committee. Thank you very much, Senator Seeberger. Next on our agenda, we have Senate File 413, and our very own Senator Pappas is here to present Senate File 413.
Thank you, Madam Chair. I'll try to be brief and quick. Minnesota is facing a retirement crisis. Declines in employer-sponsored pensions and lack of savings impact people's ability to achieve a secure retirement. Nearly half of Americans nearing retirement age, 65 years old, have less than $25,000 put away, while 1 in 4 has less than $1,000 in savings. In Minnesota, 32% of private sector employees, approximately 70,000 individuals, work for an employer that does not offer a retirement plan, and employees of color are significantly less likely to have access to workplace retirement plans. Today, 16 states have either passed laws or have pending legislation that outlines new programs for private sector workers. Of that number, 8 states have implemented the program with positive results. To get ahead of the retirement savings crisis and help workers save for their future, the bill before you establishes the Secure Choice Program, a public-private partnership for retirement savings that allows workers to set aside wages through an easily accessible auto IRA plan. Members, briefly, this establishes establishing the Secure Choice Retirement Program requires the Board of Directors of the Minnesota Secure Choice Retirement Program to operate an employee retirement savings program. The program must begin by January 2025. Under the program, employee payroll deduction contributions are transmitted on an after-tax basis by covered employers to individual retirement accounts established under the program. It requires the board to establish procedures for opening a Roth IRA, a traditional IRA, or both a Roth IRA and a traditional IRA for each covered employee whose covered employer transmits employee payroll deduction contributions under the program. Contributions must be made on an after-tax basis unless the covered employee elects to contribute on a pre-tax basis. In your packet, I wanted to point out there are several letters of support from small businesses, from the Council on Nonprofits. There's a letter from the Minneapolis Chamber supporting the program, and a briefing from the AARP. Members, we have the A4 amendment, delete all before us because we had an engrossment problem. And council can further explain that if you wish. It just wasn't properly prepared from the last committee. So this is basically our bill, except the changes that I'm proposing have already been incorporated into this delete all. And these changes were requested by the Minnesota Chamber and others. If we turn to page 2, line 3, we are exempting businesses that have less than 10 employees. Employees of those businesses can still opt in as individuals. And I think that would also cover, I know Senator Dornick has brought this up numerous times, like newly established business who maybe have less employees, might have trouble incorporating all the labor laws, and so this would exempt them until they have 10 or more employees. I knew you'd be happy with that. You're smiling at me. The investment is into the State Board of Investment, which we know they do very, very well. It was requested that I clarify the opt-out situation. So it's an auto IRA unless the employee chooses to opt out. So I wanted to just point out that language on page 5, line 27, line 29. It says they're enrolling all their employees unless the employee has elected not to contribute. So they have that option. That's new language. On page 6, line 5, again, clarifying if the covered employee does not elect to opt out of the program. Other new language requested on line 23, 24 on page 6. The board must provide covered employers with written warnings for the first year of noncompliance before assessing penalties. That was a specific request so that businesses would have time to adjust and just get a warning letter, say, hey, you're supposed to be doing this. New language is on page 991, again, opt-out language, so we're very clear with that. There was another request that there be a report back to the Legislative Commission on Pensions and Retirement that actually was in the original bill on page line 928 and on page 10, line 3. I'm looking to see if there's any other new language. Yes, on page 12, line 10, we did delay the implementation from October 2024 to January 1st, 2025. And the last phase, they have up to 2 years. It'll be a phased-in process. That also was a request that the final phase be 2 years later. But it is up to the board how they want to phase that in. So, Madam Chair, I have 2 testifiers. Maybe you could just come up for 1 minute. Karen Swenson, if you're still here.
And
she's on Zoom?
Yep.
yes, we
I'm on
have.
Zoom. Yes.
Hello, welcome to the Senate Labor Committee, Ms. Swenson. Can you hear us okay? Very good. And if you would introduce yourself for the record, we look forward to, and also tell us where you're testifying, please, testifying from, and we look forward to your testimony.
Yes. Good afternoon, Chair McEwen and Labor Committee members. My name is Karen Swenson, and I'm the Executive Director of Meadow Park Preschool here in Rochester, Minnesota. I have been in my current role for 30 years and have been in this business far longer. I'm excited to testify in favor of these bills and establish the establishment of the Minnesota Secure Choice Retirement Program. Running a child care business is a really difficult practice. While I'm passionate about the kids that we teach, the families we serve, and the teachers that I hire, the margins are so thin and the public investment is so low that we are in a prolonged and deeply troubling staffing crisis. Offering quality care is expensive, and families with young children can only afford to pay so much. This is why it's difficult for me to offer competitive wages and benefits to employees. Unfortunately, right now, I can only offer an average wage of $15 and no benefits except for paid time off. This is especially tough because childcare teachers are really the workforce behind the workforce. For years, I've wanted to be able to offer my employees more benefits, especially some type of retirement package. Nearing retirement age myself, I know how important it is to start saving early in one's career, and that those years of savings and compounding interest can really add up, but they can also fly by very fast if one is not planning. For my young teachers and staff, I often encourage them to try to save for the future, but there has never been an affordable way to put money away for their future. Secure Choice would be a great tool that my staff could use to start their retirement planning now. This program is a starting point, and I would love to see it eventually evolve to offer more options, including provider match. Ideally, we will one day have a child care system that will allow independent child care centers like ours, a nonprofit, the ability to participate in such a match as we work towards a system where early childhood educators are treated more like their peers in the K-12 system. Thank you for letting me testify, and I urge you to pass this important tool to help our child care workforce. Maybe this system is a little too late for my generation, but I'm hopeful for our future that it can help the next generation of workers. Thank you so much for your time.
Madam Chair, I did forget to move the A4 amendment, and thank you, though, Ms. Swenson.
Yeah, thank you very much for your testimony, Ms. Swenson. And I was going to ask Senator Pappas if you'd like to take care of that now, adding those amendments.
Yes, I'll move the A4 amendment.
Okay. Senator Pappas has moved the A4 amendment. All in favor, please say aye. Aye. Any opposed? The A4 is adopted.
Thank you, Madam Chair. I also have the A5 amendment, if that could be passed out, and I'd like to ask Ms. Cook to come up and address it.
Very good, thank you. We have it. We already have it passed out. All right, we already have it in our packets, members,
Okay.
the A5 amendment. And to the A5 amendment, thank you.
Thank you, Madam Chair, members of the committee. For the record, my name is Judy Cook. I'm here today on behalf of Insperity, which is a PEO, and this is designed to be a clarifying amendment. You may remember from our work on Earned Sick and Safe Time, professional employer organizations, PEOs are also known as employee leasing companies, and they provide comprehensive human resource solutions to their clients, who are typically small and medium-sized businesses. This language is consistent with language found in the UI statute 268.046. I also understand this language is a little dense, and so I think we're going to continue to work with Senator Pappas and Ms. Lencheski and council to try and make it a little easier to understand. Basically, all this says is that if a PEO offers a qualified retirement plan, the tax-paying employees will be part of that, and the PEO can assist them in being a part of that, and if not, they would be in the Secure Choice Plan. I really want to thank Senator Pappas and Ms. Lencheski for working with us on this clarifying amendment, and I'm happy to answer any questions.
Thank you very much.
So, Madam Chair, I'd move the A5 amendment.
Very good. Thank you, Senator Pappas. On Senator Pappas's motion to adopt the A5 amendment, all in favor, please say aye. Aye. Any opposed? The A5 amendment is adopted.
Madam Chair, I guess, do we have another witness online? I don't know if we have.
We do have,
Mr. Heredia Rosario?
I do, yes, I have two. I have, next on our list was
Kadun wanted to testify.
Mary Jo George, and then also after that we had Nicolas Heredia Rosario. Would you like to proceed in that order, Senator? Do you have a preference? Welcome. If you'd introduce yourself for the record, we look forward to your testimony.
Yep. Good afternoon, Madam Chair, members of the committee. Mary Jo George with ARP Minnesota. And on behalf of our membership, we are in strong support of Senate File 413, and we want to thank Senator Pappas for all of her work on this. It's been a long time in coming. As you've heard, there's just, workers are not saving enough for their future, and so we are very concerned an unacceptable number of middle-class folks will be retiring without enough money for medicine, utilities, and rent. And we know we can get ahead of the problem with this program. I think it's really important to note that our survey data shows small business owners want to offer retirement savings, but it's oftentimes very costly, and employees want to save, but it's not easy to do on your own. It is a real problem of access. So under the Secure Choice plan, we think that it's an easy plug-and-play program, both for employers and employees. And in fact, employees are more likely, 20 times more likely to save when they can do so at work. And I think what we're seeing is great success across the nation in terms of the other states that have these plans. 16 states do have some type of retirement plan like this. And then just lastly, I would say, increased retirement savings goes just beyond the individual saver. We can actually save the taxpayers money too. We have studies that show that implementing something like this could save as much as $258 million in public assistance over 10 years alone. So we think it's a win-win, and we'd urge your support. Thank you.
Thank you for your testimony. Next, we have Nicaris Heredia Rosario. I apologize if I'm mispronouncing your name. Welcome to the Senate Labor Committee. If you would please introduce yourself for the record and let us know where you're testifying from. We look forward to your testimony.
Thank you so much. Good afternoon, Madam Chairs and members of the committee. My name is Nicaris Heredia Rosario. I'm testifying from St. Paul, and I am here. I'm the Legislative Director for the Minnesota Council on Latino Affairs, and I am here today to express our support for Senate File 413. As a state agency, our council advises elected officials on matters affecting the Latino community, and we have found that preparing for retirement is particularly challenging for Latino Minnesotans. Despite having one of the state's highest labor force participation rates, our community is at a high risk of not having retirement savings. In fact, 46% of Latino workers in the state of Minnesota lack access to an employer-provided retirement plan. During our community listening session last summer, we heard many stories from community members who have worked for years but have not been able to save for retirement because their employers do not offer one. And many of them expressed their concern and their worry because they do not have financial security once they retire. As it was mentioned before throughout testimony and from Senator Pappas, we know that without payroll deduction plans, it can be very difficult for workers to save. And many individuals in our communities also support family members in their home countries, which makes it even more difficult and challenging for them to save for retirement. So we believe that making retirement security available to everyone starts with making it easier for workers to save. And this bill, we believe, aims to do just that. So for this reason, we urge this committee to support this bill as it will help ensure that all Minnesotans can secure their financial future. So I thank you for your time.
Thank you for your testimony. And next on our list, we had Beth Cadoon. Welcome to the Senate Labor Committee.
Thank you, Madam Chair. Members, my name is Beth Cadoon. I'm with the Minnesota Chamber of Commerce. I'm also here speaking on behalf of John Reynolds with NFIB. He apologizes. He had another commitment, so was not able to be here. We both thank Chair Pappas for her willingness to work with us on our concerns with this bill. We especially appreciate the amendment, which addresses one of the main issues we had with the bill, which was it did not have a small business exemption, and now it does. This makes it more similar to the other states that have enacted a similar program, as most of those do have a small business exemption, recognizing that for many of those small employers, they do not have sophisticated HR systems. So this will really help, like I said, mitigate the impact on those smaller businesses. We also thank the Chair Pappas for adding the one-year warning in the penalty section. We think that's very important. We look forward to, as this bill moves along, to see if we can further define the penalty, as we do believe that should really be addressed by and set by the legislature, not by a non-elected board. And then we would also ask that as this bill moves along, that the cumulative impact of this proposal, along with the other new employer mandates that are moving through the legislature, be considered for the timing of the phasing, the implementation, because a lot of these new employer mandates, such as sick and safe time, the 24-week paid leave program, really do impose substantial changes for our employers with new requirements, record keeping, and really great changes in their current employment benefit set. So we're just asking that that be considered when we're looking at the totality of the bills being passed. Thank you.
Thank you for your testimony. Members, I'm going to open this up to discussion. Before we do that, Senator Pappas, any last words for
Madam
members?
Chair, no, in the interest of time.
Thank you.
I won't say any more.
Thank you. Yes, Senator Kubik.
I'll just be quick, too. In the interest of time, I had a couple of constituents, Madam Chair, reach out to me about this bill, and then I read up on it, and it was wonderful. And I went to Senator Pappas, and she graciously allowed me to also be an author on it. So thank you.
Very good. Thank you, Senator Kubik. Senator Liskey.
Thank you, Madam Chair. Again, very briefly, I haven't gotten a chance to fully go through the amendment. Can you tell me what size small businesses are exempt, what number you chose?
Senator Liskey, under 10.
Okay, thank you.
And I would note, I appreciate that those employees can still opt in on their own if they want to, but then the business owner doesn't have to. Yes, Senator Marty.
Madam Chair, I very much like the bill and glad to see it moving forward. Senator Pappas, because you were here earlier when I mentioned this to Senator Mann's bill, severability clause is totally unnecessary. Do you mind if I strike that? Section 10, page 12, lines 3 to 4. I'd like to move to delete that.
Senator Pappas?
That's fine.
Okay. Senator Marty makes an oral amendment to strike the severability clause in the bill. I think that's sufficient detail. It looks like it's section 10, and then we would renumber accordingly. All in favor, please say aye. Aye. Any opposed? Senator Marty's motion is adopted. Members, any further discussion on Senator Pappas's bill? Yes, Senator Grunhagen.
Oh, thank you, Madam Chair. Yeah, we definitely need retirements, and Senator Pappas, I agree with that. You heard some of the concerns that just the overwhelming amount of bills that we're passing in terms of small employers. Is there any graduated, I didn't see it in your bill, I didn't have that much time to review it, but is there any graduated penalties or flexibility for the Attorney General, to enforce penalties established by a non-elected board? That does trouble me a little bit, that there's not a little bit of oversight from the legislature on this.
Senator Pappas?
Yeah, Madam Chair, Senator Grunhagen, yeah, I agree with you. We are researching right now what other states are doing in terms of penalty caps, and it is our intention to put a cap on it in the Judiciary Committee, which is our next stop. We just haven't quite finished that research.
Thank you, Senator Pappas. Senator Grunhagen, follow up.
Yeah, just real quickly. I'd be a lot more comfortable if there was some legislative oversight on increasing the caps or, on this unelected board making up these decisions. So,
Senator Grunhagen, that's what I just said, is the legislature will determine the penalties at the next stop. We just haven't finished our research.
All right.
So you will be happy with it when you see it on the floor.
Thank you, Senator Pappas. Senator Grunhagen, last word.
The only thing I'd say is that most men need things repeated twice.
Okay.
I also said that in my opening presentation, so that was 3 times.
Very good.
I realized I talked fast.
Senator Pappas, I believe that's all. Thank you very much for your work on this bill. This is a wonderful program. We're really excited to see it moving forward. Would you like to motion?
Thank you very much.
Make the motion.
Madam Chair and members, I move that Senate File 413 as amended be recommended to pass and send to the Committee on Judiciary.
Thank you, Senator Pappas. On Senator Pappas's motion, all in favor, please say aye. Aye. Any opposed? The motion passes. Thank you, Senator Pappas. We are going to move ahead as long as we can here, and next on next on our schedule, we have Senate File 1599, and Senator Putnam has joined us this afternoon to present that bill. Thank you for your patience, everyone. We've been trying to move as quickly as we can here expeditiously. Welcome, Senator Putnam, to the Senate Labor Committee. And I will just hand it over to you. I think we go straight to your presentation. You don't have any amendments or anything at this point, so after you, to your bill.
Thank you, Madam Chair, and thanks, friends in labor. It's good to see you again. Today, we have a really cool opportunity to hear from some people who have actually profited from and grown from this program that I'm presenting to you before. You know, sometimes, go on a limb here, sometimes legislators present bills and they defer to their testifiers because they don't really know what's in the bill. But in this case, I'm doing it because our testifiers are awesome. My friend Akitha here, she actually likes being in a crane. Big cranes, she enjoys that. And so I'm going to be as quick as I possibly can so you can hear her stories because they are phenomenal and they are inspiring. Now, the bill before you today will build on a private-public relationship between Independent School District 294 and the Operating Engineers Local 49 Apprenticeship Program. We all know these days it's difficult to get young people interested in a career in a way that is safe, particularly a career like this. No 16-year-old should be hanging out on a crane, but this program has leveraged technology and the capacity of a public school to build interest and skill, and it's connected to the next step in career development as well, which is an apprenticeship and a good job. With bipartisan support, this program was started just 2 years ago, and yet it has already exceeded expectations. We appreciate the opportunity to present it to you today, and so now I'd just like to turn it over to our testifiers, if I may, please, Madam Chair.
Yes, please. Welcome to the Senate Labor Committee. We look forward to hearing your testimony in support of this bill. Whomever would like to go first, please proceed. And if you would introduce yourself for the record, please, that would be appreciated. Thank you.
Thank you, Madam Chair and members of the committee. My name is Akithia Lloyd. I am a crane operator by heart, but my position at International Union of Operating Engineers, Local 49, I'm a career navigator, and my job entails recruitment and connecting underrepresented populations and high school graduates to opportunities within the industry. So as far as our Stride K through 12 is partnered with Local 49 to offer all Minnesota high school students a Operating Engineers Pathway program. It's designed to give high school students, you know, an introduction to what we do on a daily basis as operating engineers. So it's a promising career path, family supporting wages, top tier benefits, also no college debt to them entering in it, and skilled jobs that cannot be outsourced. So it also offers flexible classes that are all online. There's 4 classes, and they consist of construction explorations, basic grade and construction math, equipment fundamentals, and basic equipment maintenance. Each class is a semester long, they're online, and they're offered through Minnesota Virtual Academy. Each high school student can earn 0.5 elective credit towards high school, 5 articulated credits for 3 of the 4 modules towards North Hennepin Community College, as well as receive 30 apprenticeship training credit hours towards the adult apprenticeship with Local 49 once they graduate from high school. Now, our program launched in 2020, and the legislature approved $100,000 funding in 2021, and more than 100 schools are involved now. And the Pathway program has 171 enrollments in the spring of this year, actually. Now, the classes typically work where the school, like the students in their brick and mortar school, if they have a free period, they can participate live with the instructor, or they can go on later on and participate then because, you know, and also a benefit to them, each class is pre-recorded. So that's also a benefit as well. And depending upon the student, you know, passing each class, the school is refunded back those dollars. But
Also, I'd like to add in is that back in 2014, I didn't, like most people, like most high school students, I didn't know anything about the construction industry myself. I didn't grow up around it. I was not comfortable around equipment. I couldn't even tell you what a foundry box was when I began in this industry. But back in 2014, when I was working part-time in maintenance at Summit Academy, which is a vocational training school in North Minneapolis, they had a pre-apprentice heavy equipment operators program there. And I decided to enroll as a student. Student full-time, single mother full-time, and a, student at the school full-time. So I was busy. But I eventually got hired on with Lunda Construction doing bridge work, building bridges, and for the past 7.5 years, I've had the opportunities to operate cranes, forklifts, loaders, dozers, skid steers, you name it. If I'd have known about a program like this in high school, I would have definitely made different choices in my life. I mean, and just to be able to, give high school students knowledge and information. Every single last one of us in this room knows that knowledge is power, and without it, we can't even make an educated decision on what we want to do with our lives. That's why I believe this program is vital to the youth. Thank you.
Thank you for your testimony. And welcome also to the Senate Labor Committee. We look forward to hearing your testimony as well.
Well, thank you. Akithia did a great job. Even though she's not in that school, she did a nice job. So thank you, Madam Chair and members of the committee. It's an interesting platform, and people always say, how can you teach heavy equipment through online? But this is what we're trying to do. We're trying to reach every student in the state of Minnesota and provide opportunities for them to come to see, to operate equipment. And it's pretty cool. And the other really neat thing about it is it's not just that the students come, it's their parents, it's their little brothers, their sisters, their other friends that come along and learn about the trades. So that's an amazing part of this. So
and ma'am, before you continue on, perhaps Senator Putnam already did this. I apologize, but could you please just state your name and any title for the record, just so we're all clear? Thank you.
Yep. Thank you. Thank you for reminding me. Mary Morum, Superintendent of Houston Public Schools, and one of our schools is Minnesota Virtual Academy. So here's the pathways. She kind of talked about the coursework, and how it works is any school in the state of Minnesota can have students be taking these courses, and people are always like, well, if they teach them at a certain time, how does that work? We allow for the flexibility for them to be recorded, and they can zoom in whenever they can. We've had some really, if you want to go to the next slide, we've had some really cool in-person events all over the state. From we were out in Shakopee, we were up, we were at Ames just a little while ago. We're at the training center. So this is where the students are actually operating. Actually, this picture, someone from the public sent it to me, and they said, well, is this? And I said, no, these are actually students. They're like, who's the person operating the machine? I'm like, it's one of the students. They were actually thinking it was someone in the trade. So it's pretty awesome to see. So. This is articulated credits. You kind of already talked about this. I always think of how we can get triple wins, and this thing is a triple win, right? It's a win for students, it's a win for the career in the trades, and it's a win for all public schools, not just my school. So it allows that opportunity for other schools not to lose their dollars. We give the dollars back to them when they complete the program. And as you can see, here's where they're all coming from. We have a heat map. This is also good data for us to see where we need to target. Akithia and I, as we were waiting to come into here, we realized, oh, we have some areas that we need to hit. And we need to talk to the schools and the people and the students to recruit in those areas as well. And then here's kind of that making sure we're hitting. We have 19 current females that are enrolled in this 22-23 school year, and we had quite a few that graduated last year and are actually working in the trades, and actually that's one of the testimonies further down. And then we also have 7 current students that identify with Black, Indigenous, or people of color. So here's our seniors. There's 56. 23 of them enter the pathway course, and then 22 have indicated that they want to work in the field. I have a current senior that up until now had never even realized college was an option for him. And
he's not necessarily going into, he's taking these courses, but he's thinking more diesel mechanics. So even though if it's not this pathway, it's realizing that he's like, so these credits count, Mrs. Moore, towards that? I'm like, yep, they do. So just having that realization is a really, really neat thing. Yeah. And then here's actually Marley. So Marley is one of my very fortunate young ladies that I had in a brick and mortar school when she was young, as a junior high student, and then I got to finish out her degree with us, and she is one of our success stories, and she is currently operating for a construction company and part of the union, and she graduated just last year. So this is Marley, and getting you ready for the real world. And then here's another one of our young gentlemen from Spring Valley. And the people do a great job, and it's fun just to watch the operators, so you can read the quote there. They provide us knowledge you need to get into this trade. So there's many testimonies, but I know we have to respect time. So here's our contact information. Jenny is not with us today, but she is the spearhead of a lot of this, and she is the force behind this. So Jenny Winkler is. And Stephanie is my program coordinator, so if anyone needs to reach out to her, and this is for everybody, they can reach out to her and ask questions and get students enrolled. So we're just hoping that you continue to support this pathway program. And I think the next slide kind of states what is that it? Oh, all right. Well, we're asking for you to continue to support this and maybe with some future money.
Thank you very much for your testimony, and thank you for the presentation. Senator Putnam, we're going to have some discussion briefly with the committee. Is there any last word that you'd like to offer before we do that?
Thank you, Madam Chair, for hearing the bill, and thanks all of you for listening so attentively. Folks, this is really cool. It's just kind of a neat thing. Just a couple weeks ago, a friend of mine did a search on Indeed, and in one day, just in the city of St. Cloud, there were 474 job openings in construction. It's a clear need. But friends, you all respect labor, and you understand it's more than just putting a body in a space to do a job. You respect labor, you respect the skill that it takes to do it. This is a chance to inspire people to develop those skills. It's a cool idea. That's all I got.
Thank you, Senator Putnam. Members, brief discussion before we are literally kicked out of this committee room. Any comments or questions? Yes, Senator Gruenhagen.
Yeah, very quickly. Thank you, Madam Chair. Yeah, I mean, what grade levels is this targeted at?
Senator Putnam, or any of the testifiers who have joined you. Grade level?
Thank you, Madam Chair and members of the committee. Grades 9 through 12.
Thank you. Follow-up, Senator Gruenhagen. Okay. Thank you very much. Yes, Senator Marty.
I'll move the bill, Madam Chair. I guess it goes to finance, or you have another step before then?
It goes to judiciary next. I'm sorry?
Jobs.
Madam Chair.
Oh, I'm sorry. It goes to the Jobs Committee next.
And Madam Chair, I was going to say that when you said this is 9th through 12th grade, I know a lot of 3- and 4-year-olds who love dump trucks, earth movers and so on.
Good call. Very quickly before we have the motion, Senator Liskey, do you have something brief you'd like to add?
Just very brief. I would like to thank Senator Putnam for bringing this forward. I think there's lots of bipartisan support. I always enjoy a chance for students to learn more, especially in jobs that generally don't get well represented. So thank you.
Hear, hear. Thank you, Senator Liskey. Senator Marty has made the motion that Senate File 1599 be recommended to pass and re-referred to the Jobs Committee. All in favor, please say aye. Aye. Any opposed? The motion passes. Thank you very much, Senator Putnam. Thank you for your testimony today as well, testifiers.
Thank you.
And with that, the Senate Labor Committee is adjourned.